Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hello, and welcome to the Men's Divorce Podcast. I am Kim Gray. I am a managing partner at Cordell Cordell, and I've been here for about 15 years now. I've been practicing law for 20. I'm in the Town and Country, Missouri office, and I'm here today with Adam Sutton, and Adam's going to introduce himself as well.
Thank you, Kim. Hello, everyone. My name is Adam Sutton. I am a senior lead litigator here with Cordell Cordell in our Marietta, Georgia office, if you couldn't tell by my accent. Just if you're curious, Marietta is one of the suburbs of Atlanta. So we practice Atlanta all the way up to the Tennessee line. I've been with the firm for almost 10 years and been practicing law a long time before that.
Awesome. Thank you, Adam. As a reminder, if anybody would like to schedule a virtual consultation, you can call the number below or visit cordellandcordell.com at the email address below to schedule your virtual consultation. So today we are here to discuss some important topics regarding divorce. And today is a little bit different because we're going to talk about something a little unique. So normally when people think about getting a divorce, you're thinking about going to trial and presenting your case and having the opposing party present their case and the judge deciding on a ruling. Today we're going to talk about a different option, and that is the best negotiation and mediation strategies. So Adam, why don't you tell us why this topic is important?
Well, it's important because it really is a part of every single case. I mean, there's a local judge here in my jurisdiction who just retired, and I remember he told me during a presentation a couple of years ago that of every single divorce case assigned to this judge, only 5% made it to the knockdown, drag-out fight at trial like you would see on TV. So out of every one of his cases, only 5% get to trial, which means 95% settle. And I remember thinking at the time, say, well, you know, that's I know a lot of cases settle, but not that many. So I did a little informal audit of my cases going back a couple of years, and the judge was dead on. Even in my own cases, 95% of cases end in a negotiated settlement. Now, there still may be court hearings and motions and all that stuff, but really only 5% get to that knockdown, drag-out trial. And there are good reasons for that. Trial is hard. The divorce is hard in general, but trial is really hard on parties. It's long. There's lots of prep. There's lots of stress. It's expensive. A negotiated settlement is your opportunity to kind of cut that off and get some resolution sooner rather than later. And plus, I joke with my clients this all the time. I trust them to get it right more than I trust judges. I mean, judges are going to do their best, but they do their best with very limited information due to just short time, short attention spans. The rules of evidence always get in the way of the judge getting the real story. But, clients, your life, your finances, your kids. I know you need some help, but I really do trust you and me as a team to get it right.
So in Missouri, where I'm licensed, mediation is required in divorce settlements. And is that the same in Georgia? Because I know it is in several other states.
Georgia is very much a county by county setup where every judge is basically the king of his or her own little kingdom.
Okay.
But I would probably say, I know I keep throwing out these high statistics, but I think this is probably about right. 98% of our courts probably require it. So it is a definite minority that will let you just skip it. And the reason the courts require something like mediation is because it's effective. And I guess just so the audience knows, what we're talking about with mediation is really kind of assisted negotiations. Most of the time, the way it plays out, me and my client are in one conference room, the other party and their attorneys in another conference room. And we have a neutral third party called a mediator that works with them, works with us, goes back and forth with offers and counter offers to either we reach a settlement and we don't. Now, that's not to say all negotiations are limited to mediation. Some cases are settled just by both lawyers getting each other on the phone and saying, hey, let's talk about this case. Some cases we settle through offers and counteroffers just through email. Some of our jurisdictions will have a judge-hosted settlement conference where basically the judge gives you an opportunity to settle before they start kind of bringing the hammer down. But most cases, 70-75% of cases that do settle at that mediation. So that really is a lot of our focus when we're talking about negotiation and how to effectively negotiate.
All of these mediation and negotiation tactics are a lot more informal than the trial. Is that correct?
That is correct. You don't really have to worry about the rules of evidence. And something I tell my clients work prepping for mediation is, the actual conference itself is pretty informal. It is you, me, and a mediator sitting around a table talking. No rules of evidence. You don't have to be called on. You don't have to formally submit anything you want the judge to look at. Mm-hmm. It is a bit more relaxed structure-wise.
Okay.
But it is very serious when it comes to what we're there for and what we're doing. We are there negotiating your financials, literally what your future is going to look like for the next 10 plus years, your time with your kids. Those are really important issues. And that's what makes mediation and negotiation in general very serious, is that the stakes are very high.
Right. And there's still a lot of prep work that goes along before you can do any type of negotiation or mediation. Why don't you tell us a little bit about what goes into that?
Well, sure. And I kind of look at prep as prep when it comes to negotiation is giving your attorney the tools that he or she needs to do a good job. Part of that is some obvious things. If we're arguing or negotiating about finances, well, we need the numbers. We need to know the bank accounts. We need to see the tax returns. We need the proof of income. We need that to kind of know what we're negotiating. And what most attorneys do, at least on the finances, and this is what I do with my clients, is we're going to build a balance sheet. I need the numbers to build those balance sheets. And also the other side is not just going to take our word for the numbers. We need to be able to back it up. So that's the first thing, is document financials, financial production. You're going to be sick of hearing that before it's over, but it really is important. Even though we're not at trial, I also think it's good to have the evidence that supports your case. If
Right.
we've got some pretty significant text messages or video or audio recordings, I want those. Now, am I going to present those like I would at evidence at trial? No, but sometimes you need that added pressure that you can apply to the other side in a negotiation. So getting that supporting evidence helps a lot. And a lot of this is done not the day before a negotiation or day before or a week before. You and your attorney are a team starting at the very beginning.
Right.
And so you start early with kind of a work list, a to-do list for a party. And then as it gets closer to negotiating sessions or mediation sessions, you kind of get a lot more specific. I specifically need this. And then a good attorney is going to tell you not just what you need, what he needs or she needs, but why. And all of this prep kind of builds up to, I think, the prep meeting between an attorney and client, sometimes 2 or sometimes 3, but that's where everything kind of gets their focus. The attorney's been giving instructions to the client's been gathering documents, gathering records, but how does it all fit together? How do you develop that strategy for that mediation or negotiation session? You're going to do that during that prep meeting.
One thing I always like to do in that prep meeting is to first talk with the client and figure out what those goals are. And I think it's important to get those goals and get a list of what we need and what he or she wants, and then we can go from there. Is that what you do?
That's exactly right. And I do kind of try to, it's a little uncomfortable with some clients, but I try to dig kind of deep in what they really want. And, I'm going to borrow from a sort of famous negotiation book, Getting to Yes here, but there's a difference between having a position and having an interest. A position is, I want X. That's fine. But an interest is why you want X. And I think that is a lot more important in a combative negotiations. And kind of a very simple example, I'm going to steal from that book, is Kim, there's one orange. You want it, I want it. What can we do?
Split it in half.
We can split it in half. Perfectly reasonable. Our position was, I want the orange, you want the orange. Let's split it in half. Now let's add something to that. Kim, why do you want the orange? Most people would say, well, I want the orange to eat. Well, the other side says, well, I really want the peels for baking. Well, now we've got different options.
Right.
That's the interest versus position. And that's a simple example. Most negotiations don't work that way. But to a degree, they kind of do when you pull back far enough. I want X amount in alimony. Well, okay, that's a position. The interest is usually, I have this bill, and this bill, and I've got to figure out a way to meet those bills month to month. Well, we can have some creative solutions to that. Or I've got to keep the house in the divorce. Well, what the client may really want is, I desperately want the kids to stay in this same school district because it's an amazing school. That's slightly different. That gives us more room to negotiate. And this does come back to the prep meeting, because you and your attorney need to work this out before you step into the actual negotiation. I think you can't always do this, but as much as possible, you want to develop your first offer during that prep meeting. You don't want to just walk into that negotiation blind. What is your starting position on custody, on parenting time, on child support, on what we do with the house? Where do you start? And I do stress, though, this is a starting point, not an ending point. Those first offers are not take it or leave it. I kind of characterize them a bit as kind of wish lists, to say, okay, we walk in there and we get everything we want. What does it look like?
Right.
That's where you start.
Right.
And that's kind of where the other side's going to start too.
So we've got to start high and put everything that we want, anything that we would ever want in this divorce, on that first list, knowing that we are going to have to negotiate. We're going to have to give a little bit, and the other party is going to have to give a little bit too. And the intention and the hope is that you guys are able to meet somewhere in the middle.
I think that's right. And that's why the day of, when we are there in that negotiation session, when we're there in mediation, I think that first offer really matters, because if we are each side starting, high and working towards the middle, well, where is the middle? The middle depends a lot on where you start.
Right.
So, and part of this depends on kind of knowing your case and knowing the other side. There are some lawyers out there where I can say, well, look, Joe, let's just cut to it. My client is really looking for this, and I know your client's really looking for that. Instead of spending 4 hours on this, let's cut to the chase. Other attorneys, if you do that, they're not going to cut to the chase. They're going to start way over here still, and now you're working up to them. So part of that is kind of knowing who you're dealing with, and that's something you should ask your lawyer.
And I think that's really important also, because sometimes if you come in with a too aggressive of a starting point, that's just saying that you want everything and she gets nothing, for example, then you do run the risk of the opposing attorney saying, well, there's nothing that we can negotiate here. We're too far off to begin with. So it is important to have those discussions, figure out the why, and come up with a reasonable starting point that still is something that would leave you extremely happy that you're willing to negotiate down.
I 100% believe that every offer, whether it's first, second, third offer in a negotiation, needs to hit a sweet spot.
Yeah.
And I'm going to use kind of money as the example because this is easy. If you offer too much money, you're leaving money on the table. If you offer too little money, the scenario you just described plays out, where we're too far apart and they walk away from the table. There's a sweet spot every single offer. And the way you know that sweet spot is prepping with your client, knowing the interest, knowing the positions, knowing the other side, and also kind of utilizing the tools that you've got available. One of those is a really good mediator. Not all mediators are built the same. Some mediators, they just send offers back and forth. Well, that's not very helpful. I like a mediator who will give their opinion. I like a mediator who will help both sides reframe issues. I like a mediator who will brainstorm, give out their ideas with the understanding that they're not the judge. They don't get to make the call, but I appreciate the input. A good mediator knows the temperature in the other room, especially if it's a mediator that I've worked with for years. If I'm starting to make an offer and then this particular mediator says, Adam, that's not going to work over there. Maybe you should try something else. What the mediator is telling me between the lines is, if you offer that, they'll walk. You need to think of something else. I really appreciate that. And that's one of the reasons why mediation gets cases to the finish line as much as they do. It's because of good quality mediators.
Right. A good quality mediator is very important, but also a very good, skilled quality attorney who has been doing this and knows how to mediate, has been in some mediations, is familiar with mediators. Finding the right attorney is crucial to being able to successfully mediate as well.
Absolutely. And because mediators, they'll say, well, I'm in the middle. I don't have a position on this. The truth is they do have a position. Their position is to settle the case. Right. Sometimes that's what's best for your client. Sometimes it's not. You need a good quality attorney that can kind of evaluate that. And I don't say this to say in every negotiation, we storm out of the room, but there's something to be said about knowing your walkaway point in advance. The side that has to have a deal is the side that's going to get the worst deal.
That's good. That's smart. That's right.
Yeah. I can't take credit for that either. Harvard Negotiation School, Getting to Yes, Uri, they developed a concept called BATNA's Best Alternative to a Negotiated Agreement. And that basically what that is you negotiate more confidently if you've got a backup plan.
Right.
And it's an alternative. Of course, trial's not the best choice until it is. Right. And kind of connected to that, I think every offer in a negotiation falls on a spectrum. On one end, we've already talked about your wish list, everything that you want. Perfect. One step below that, well, I made some compromises, but this is still a really good deal. Mm-hmm. One step below that, I made some more compromises. I'm kind of uncomfortable with this, but big picture, this is probably fair. One step below that, I'm really uncomfortable. I've got a lot I don't like about this, but it's better than taking my chances at trial. One step below that, I would rather take my chances at trial.
Right.
Every single offer is going to land somewhere on that spectrum. And if an offer lands you on, I'd rather take my chances at trial, that's okay, because you're not locked into this negotiation. And that gives you confidence, that gives you power negotiating, because the other side needs to pull you back to the table.
Right. So let's talk about the day of mediation. Mm-hmm. When we're there, when you're sitting at the table in your room with your client, how do you evaluate those offers? What does that look like? Tell me a little bit about that.
Well, you start with prepping your client before that meeting so they know kind of your overall strategy. So when you walk in there, you've got a plan. And the first thing I always tell my clients is to, don't freak out about the first offer from the other side, because it is going to be that wish list. So that's the first thing, is stay calm, cool, collected. Acknowledge that first offer is going to be a wish list. Just because they say it doesn't mean we have to accept it. I think things really kick into gear in a mediation in the second offer. The second offer from them, the second offer from you. There's a lot you can read into that second offer. Does one side refuse to move? Then this is going to be a short mediation. Do they move a little? Well, okay. We can still probably settle this, but we're going to inch our way there. We're here a long time. Does the other side move several feet at a time? That tells us they want a deal. How do we take advantage of that? And you can read all of that usually in just by evaluating the second offer. So just by talking about that, just by working through it with a client, if you have a good trusted mediator, I'll have these discussions with the mediators in the room. and get their input on that too. But that's the first thing you do is you really dig in on that second offer. Another thing that you do is, and you do this before and leading up into that negotiation, is you look for leverage points. And that's a fancy way of saying strengths and weaknesses to a case.
Right.
So an example of that is, let's say, custody is going to be on your side. That's not disputed, but we're fighting about child support. Let's say dad's going to get primary custody, but mom is just adamant. She just can't pay more than X amount of child support. But the judge is going to order something higher.
Right.
That's a leverage point. So how do you use that to your advantage in negotiations to kind of get what you want on other issues? One I see a lot is if you go to court, I can tell you in Georgia, if you're fighting over what to do with a house, the judge is going to order the house sold. That's just what they do. It's easy for them. So if we're in a negotiation where the other side really, really wants to keep that house, well, this sounds a little crass, but this is part of the process. How much is that worth to them?
Right.
You want me to deviate from what I know I could get at court. Fine. What's in it for my client? And the reason it's important you identify those is, let's say in that same scenario with the house, my client just said, fine, she can do a buyout of the house. I don't care, move on. Well, we've just lost that leverage because he's just given it away. Now, when we're talking about custody or finances or something like that, I've lost something I can use to apply pressure. So you identify those leverage points and you use them. And it really is kind of pitting one issue versus another. It's pitting strengths versus weaknesses. And it starts with identifying it. And I think it starts with explaining to the client, as an attorney, explaining what I'm doing.
Right.
I know some clients who say, I don't care how the sausage is made, just get it done. I respect that, but I don't think that's the way you need to go about it on something like this, because I need a client's help. Right. I need that facts. I need those information. I need to know his positions and interests. So he needs to understand kind of, if I'm posturing to a mediator on an issue, why I'm doing it. That goes a long way in negotiation, is just identifying those issues and using them to your advantage. I'm really shocked at how many lawyers in negotiations don't do that. I'm a big supporter of working out agreements. We want this thing to resolve. We want this thing to settle, but you don't just give everything away just to get a settlement.
Right.
Kind of a way I frame it with my clients is, and I do this almost every time, I say, all right, John, we're going into this mediation to make a deal. So we're going to bust our butts today to make a deal. Mm-hmm. But we're not going to take a bad deal just to get a deal.
Right.
It comes back to having that backup planning, having that power to walk away again. Even if you never utilize it, you've got it there so you can be more confident. And it all kind of ties in together. Negotiating strong is being confident. Being confident is having your backup plan. Being effective at mediation is identifying interest as opposed to just positions. Identifying those leverage points and not just throwing the leverage points away, utilizing them. And I don't say all this to say, oh, client, you've got to be an expert in all this. You don't.
Right.
That's why you've hired lawyers. This is what we do. Practicing law is more than just knowing a statute, knowing how to admit evidence. This is part of the job, but it's also part of the job to educate clients. It really is a team effort in a negotiation. And another kind of thing I like to tell my clients all the time is, if our relationship, if this were a boat, I'm the captain of the boat, but you're the owner of the boat. I'm steering the ship, but you're directing the actual final destination. That's how you approach a mediation. A lot of people say you don't win or lose in mediation, you settle, but I disagree. I think that's how you win at mediation, and how you win at mediation is you maximize your results.
Yeah, I think you win at mediation if you come away with an offer and an agreement that you're happy with.
That's exactly right. It's never perfect, but it can still be good. It can still be really good. It can still meet your interests that you walked into that negotiation looking to accomplish. You've got to put the work in, and then you've got to identify the items, the tools, the strategies that help you, and then treat the negotiation like a partnership.
So when you're talking about going into a mediation, how long do these usually last? I mean, I know that I've been in lots of mediations, and I've been in them sometimes from morning until it gets dark, because sometimes you have to do what you have to do to get a resolution if that's what's in the best interest of your client. Do you find the same thing?
I do. I think my shortest mediation that actually settled took about an hour and a half. My longest single session mediation, we went solid for about 12 and a half, maybe 13 hours.
Wow.
Most mediations, I think land about 5 to 6 hours. I think that's pretty typical, at least what I've seen in my cases.
So attending mediation is not easy, but it's oftentimes necessary and oftentimes the best way to get the best result for your client.
I agree. And a lot of clients feel that that if I don't settle, then it's wasted. I disagree. We get so much information even from a failed mediation. So let's say we put the work in. Let's say it's one of those marathon mediations. We've been going 8-9 hours strong, and it just falls apart at the end. It's unfortunate, but it's fine. All that really means is at the end of the day, we were just too far apart. But how much did we learn about our own case, our own strengths and weaknesses? Because when the mediator is coming back with offers and counteroffers, they're pushing us. So how did we respond to that pushing? That tells us where our weaknesses are in our case going forward to trial. It also tells us where the other side's weaknesses are. Where did they push back? Where do they concede? What are kind of the really touchy points? Where are the kind of the pressure points we can use at trial? You can gain so much information even from a mediation that doesn't settle. And there's no rules that say that you only have to have one session. There is a concept called negotiating fatigue that is absolutely a real thing. You get 4 or 5 hours into this, you are negotiating strong, counteroffers, back and forth. The mediator keeps saying things that make you angry that the other side's saying, and you've got a mediator talking in one ear, you've got your lawyer talking in the other one. You're 10 hours into this, your brain turns to mush, you're done. That is okay too. Everybody has their limit. We don't want to push you beyond. It's another thing you need to be aware of is your client's limits are to the point where they're just not negotiating well like they should. They're human. Maybe we take a break. Maybe we stop for the day. I'm not a real big fan of doing multiple mediation sessions, but if I have a party on my side or the other side who's burning out, we'll do that. I've had a case where we've gone to 3 mediations. Every one of them were 7+ hour marathons.
Wow.
But we settled at the end of the day. It took all 3 days, but we got there. It was just a lot of work, a lot of emotions, a lot of complicated financials, throw in custody issues. It was a lot to work through. Right. And that's the other thing you also do in a negotiation or a mediation is, it sounds like a cliche, but it's true, is you take it one step at a time. You can't just do the whole thing you expect within 2 offers. You're going to resolve, all the issues stemming from a 20-year marriage. It doesn't move that fast. You take it one piece at a time. You work through each piece till you reach a settlement. Or sometimes you don't. And if you don't, you're still walking out in the mediation with your head held high because you're empowered for the next steps in your case.
Well, that's awesome, Adam. Thank you so much for talking with us today about negotiation and mediation strategies. I think it was really helpful. If you want to schedule a virtual consultation, see the numbers on the tagline below. Call 1-866-DADS-LAW or visit CordellCordell.com to schedule that virtual consultation.
We're all here and would love to speak with you.
Yep. Thank you.